At Raju Law, we don't just provide legal services, we provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving you time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello and welcome everyone. I'm Manshi Katira and I'm absolutely delighted to have you with us for another episode of Immigration for All, brought to you by Naroha Global and proudly powered by Kulna Tech. If you are been tuning in, you know that we recently rebranded our Monday Live series to Immigration for All, a name that truly reflects our mission to make immigration knowledgeable, clear, accessible, and practical for everyone, no matter where you are in your journey. And here is some exciting news. Our show is now officially available on Spotify and Apple Podcast. Whether you're commuting, working out, or just unwinding at home, you catch all our episode anytime, anywhere. Today, we are diving into a topic that's making headlines and raising questions across communities and legal circles, like recent changes in US Alzheimer law and policy. Asylum is a life saving legal protection, but navigating the process is complex. And recent updates have introduced new rules, faster timelines, and procedural changes that that every applicant and advocate should be aware of. So, if you or someone you know is seeking Alzheimer or supporting someone through that journey, this episode is especially important for you. Now, without any further delay, let's welcome our special guest, Mr. Mahajan, Principal Attorney at Raju Law.
Thank you very much, Manashi, for inviting me here. How are you?
I'm good. How are you, sir?
I'm good, good. Thank you very much. So yeah, without further delay, let's start discussion about recent updates about asylum law and policy. Let me start presenting the yeah. All right, yeah. So thank you, Manashi, again. So before as Manashi said, our today's topic is recent changes in U.S. asylum law and policy. And let me give you some disclaimer. Since January 1 of this year, especially when our new president, Donald Trump, he took over power for the second time, there are a lot of changes in all over immigration world. Specifically, there's a lot of changes in asylum cases. Is there policy application everywhere, and it's really, really difficult to talk about everything in one episode, one presentation, because it's so big, so many topics. At the same time, there are some kind of changes. Those are not settled yet. Those are not fixed yet. That's why I'm not going to discuss those here today. For example, let's say USCIS took a policy and then someone filed a lawsuit against USCIS to halt that policy. And then the case is pending in one of the federal courts, or let's say in the Supreme Court. So we do not know what would be the outcome of those lawsuits. That's why we're not going to discuss those, because unless and until a fixed outcome is coming from those lawsuits, there's no point discussing those things. I know a lot of a news media, they talk about those things. It's good as a news, but in terms of application, it's not necessary, because if the case is pending in the Supreme Court, unless we know what would be the outcome of this case, there's no point discussing those things, because it's just a wastage of your time and my time. That's why we're not going to discuss those today. Similarly, so let's say a congressman from some state raised a bill anytime someone raise any bill in a lot of news media, they talk about that thing, the prospective outcome, prospective implication, application, blah blah blah. However, let me tell you one thing. A bill being raised and then it get passed and then it get implemented, it take a long time. Not only long time, more than 95% of the bill that being raised in Congress will never pass. That is the track record of the bill, life cycle of the bill. So there's a whole complex procedure of bill raising, getting passed in one chamber, going to another chamber, and then president sign it, and then it goes to the department for application. It's a huge process, and more than 90% of the bill will never see light, right? So there's no point discussing those things. So that being said, I'm not going to talk about any issues that is under active litigation in any federal court or any immigration court. Similarly, I'm not going to talk about any bill being raised by any of the congressmen, because those are like a pointless discussion. I am only talking about the things that has been implemented, that has been in effect, so that these are the things you need to follow now. So those are the topic. And even those things, there's a lot of things that I cannot cover here today, because I have to keep in mind that I try to make out my presentation within 15-20 minutes, so that people will not be bored. So if there's any topic left over, I'll probably talk in another day. So today we're going to talk about recent changes in US asylum law and policy. So the first one is expansion of expedited removal. So what it means is, let me read the slide first, and then I'm going to explain it. Expedited removal permits DHS means like a Department of Homeland Security, to summarily remove individuals without a hearing if they lack valid entry document or committed fraud, unless they express a fear of return. So all it means is, if you enter America without a valid papers, without a valid inspection, and if you cannot express a fear of return, then DHS officials, Department of Homeland Security officials, most likely ICE and other border security people, they can deport you immediately, right? Deport you without any hearing in any immigration court. Now, excuse me. Previously, this was only active within 100 miles of US border and within 14 days. So if you're caught within 100 miles of US border, like most of the time US Mexico border, sometimes US Canada border, and within 14 days of entry, if you cannot show a valid paper and if you cannot express a fear of return, they may remove you with the expedited procedure. However, under the new change, they can do that anywhere in the United States. There is no miles requirement from the border. So even if you are, arrested, let's say in the middle of the United States, let's say Kansas, the state of Kansas, you are arrested there and you do not have a valid document, and you cannot show the fear of return, then they may deport you without any court hearing. So this is a major change in last 6 months. So short point from this point is, if you're caught anytime in United States without any valid paper, you have to express fear of return if that is valid. If it is a true fear, you must say that. If you do not say that, there's a big chance they are going to deport you immediately with the expedited fashion. So it's very difficult for unauthorized peoples. The next one, imposition of asylum and related fees. So traditionally in America, asylum applicants were treated very humanly. People knew that they have difficulty in their home country. Many of them are very poor, so there is no asylum application fee. There was a lot of nonprofits, they would help free. There's a lot of benefits for applying for asylum. However, effective from July 22 of this month, just a few days ago, July 22 of 2025, USCIS began implementing mandatory fees for asylum-related filings. $100 fee to submit Form I-589. So I-589 form is the form for asylum application. So there's a $100 fee plus $100 annual maintenance fee for asylum applicants with pending adjudication. Sometimes you hear that someone's case is pending for 5 years, 6 years, 7 years, 8 years kind of thing. So you have to pay $100 annual maintenance fee for as long as the case is pending. Also, $550 fee for the initial application for an employment authorization card. You know that anytime anybody applies for asylum, within 6 months they are eligible to apply for EAD card, meaning work permit. So when you apply for work permit, you have to pay $550 for initial application. Also, 275 for EAD renewal for asylum seekers. So let's say initially you get 2 years of EAD card. After 2 years over, you have to apply for renewal. Then you have to pay $275. One thing I must tell here is that any kind of fee, right? Those are very subject to change, and USCIS changes their fee structure very often, very often. So even though, like today, I'm saying, $100 fee to submit your I-589 form. 6 months from now, you come and say, hey, you said $100. Now they're charging $200 because they probably raised it, right? So fees are very subject to change. Also, forms. Most of the forms either they change it or they update it. So it's very difficult for me to say the exact thing because USCIS will change it very frequently. So my advice to you, anytime you apply for anything, please make sure you follow the latest data, latest fee, latest form, latest requirement, everything. And the best place to get latest information is www.uscis.gov website. And also our law firm, we try to be very proactive in terms of all the changes. We try to follow all the changes so we can give you latest information. And also the government website, www.uscis.gov. That's a very reliable place to get latest update. Next one, termination of the use of CBP1 app. So there was an app, and the function of the app was to kind of guide you to cross US-Mexico border in a more legal way. So there's a lot of controversy about this app, and Republicans who are in power, they did not like it. So the CBP1 app, previously used to schedule port of entry appointments, was discontinued and replaced with CBP Home, a tool primarily intended for self-removal and departure compliance. So this is kind of like the 180-degree opposite function of the different app. So CBP1 app was designed for schedule port of entry appointment so that you can enter America in a more legal fashion and follow all the rules and regulations kind of thing. And now it is replaced with a new app. It's called CBP Home. The purpose of this app is self-removal and departure compliance. Well, this is the land of the law. You have to follow it. So the purpose of this presentation today is to just keep you posted. I know many people don't like it, but hey, this is the land of the law of the land, so you have to follow it. Also, asylum seekers presenting at port of entry are now frequently denied access to fear screening. So what is fear screening is, as I said earlier, anytime you enter America, you cannot show a valid document. You have to say a fear of your life, fear for your life if you go back to your home country. Now, it happens many times when you show up in the port of entry in the land border. Many CBP official may not even let you talk about your fear, right? So try your best anytime you go. If there's a real fear of threat for your life in your home country, if there's a bona fide fear, you must say it very clearly, very clearly. And if you're not fluent in English, I recommend people to write it in a paper with a clear pen, like, hey, I have fear for my life if I go back to home, and show them with the paper, so that even if you do not speak good English, you can express your intent, right? That's very important for asylum seekers in the port of entry. All right, increased interior enforcement and in-court arrest. So traditionally, there are some places in America that were recognized as sensitive locations, and ICE agents and other law enforcement agencies, they would try to avoid those places. And very common sensitive locations are, like, I would say, courts. Courts were considered as a sensitive location. Churches or any kind of religious institute, any facilities that would help, like poor people, homeless shelter kind of place, those are considered sensitive locations, and ICE and other law enforcement agencies, they would try to avoid those places. But now they do not follow that rule anymore. So ICE has resumed enforcement actions within the premises of immigration courts. That's why you hear that a lot of time people show up for hearing either in USCIS office or immigration court, and then ICE will arrest them and ICE will deport them, right? So of course, ICE cannot deport someone unless there is a deportation order pending for that person. However, everybody's in fear. Everybody's are scared about this thing. And ICE people, ICE polices, they're really arresting people from immigration courts, USS offices, including the arrest of individuals during master and individual hearings. This marks a departure from the prior sensitive location policy, under which immigration courts were presumed enforcement free zones. Also churches, churches were also like sensitive location. It was not like a legally enforcement free zone, but like a lot of ICE police and other people, they would try to avoid that, but they don't do that anymore. So churches are not safe place anymore. All right, compressed evidentiary submission deadline. So this is a big change, and me as an attorney, I am suffering a lot for this. So the deadline for submitting evidence for individual hearings has been shorted from 15 days to 10 calendar days before the scheduled hearing. So what happening is, not only individual hearing, for any kind of hearing, any kind of motion, previously judges and court clerks, they are more lenient, more flexible. And if we apply for a motion for continuance and other thing, we get more lenient kind of treatment from the courts and USCIS officers. But now they are more strict, and the reason they are strict is because Department of Justice, they issued some memo for immigration judges and USCIS officers to be more strict. And they care about their job. They don't want to lose their job. That's why, like, they are very strict to us. And me being an attorney, if I am strict, I don't have enough time, I have to force you, right? You being my client, I'll tell you, hey, I don't have enough time, please submit everything. So a lot of time, people come to me and say, hey, my friend submitted this asylum application 5 years ago and they did not submit anything at the time of submission of their application. Now you're asking me to submit everything in the front. Yes, because the situation has been changed. It's a very different situation. So there's a very compressed evidentiary submission time frame, so you have to follow it. Otherwise, if you cannot provide information and document to me, I cannot submit it to the court. If I cannot submit it to the court, your case would be weak, you may lose your case. So please take it very seriously. I tell that to my clients, and also I'm telling this in this public place. Please take it very seriously. A lot of people, a lot of asylum applicants, they do not want to submit information and documents. Without information and document, your case would be weak and you have a very, very less chance of getting approval. So please pay attention. All right, stricter standards for granting continuance, as I said. So let me first talk about what is petition for continuance. So let's say you have a court hearing 1 month from now and you're not prepared, and you need some more time for some reason. Then we can submit a motion for continuance, meaning we can request the judge to reschedule in a later date. Now, previously it was very easy, but now it's very strict. So UIR is the office who will take care of this matter, now mandates the continuous request must demonstrate extraordinary circumstance to be granted. I put like underline, extraordinary circumstance to be granted. Previously, common and acceptable justification such as late retention of counsel, I could say, Your Honor, my client just retained me like 10 days ago, I need more time to study this matter. Now they are not going to accept it. Difficulty in securing supporting documentation. I would say, Your Honor, my client is from a country, there is no functioning government, they need more time to get documents. Now, most likely they will not accept this argument anymore. Witness unavailability. I would say, Your Honor, I have two witnesses to be, testify in the hearing, and we're trying to communicate with the witness. We need more time. Nowadays, judge may not listen to me. Those are like likely to be rejected unless the applicant proves these challenges are both unavoidable and beyond their control. So, I make it like a, bold and underlined. So unavoidable and beyond their control. So this is very hard to prove that those situations are unavoidable and beyond their control. So it's very difficult for immigration attorneys. And let me tell you something. A lot of immigration attorneys in big cities like New York, Washington D.C., Los Angeles, they stop taking any cases because it's very difficult for them to maintain all these things and go to court and present your case and argue for you. So a lot of my friends who are immigration attorneys, they are not taking case anymore. We are still taking cases because I really want to fight for you, but you have to cooperate with me. You have to provide me all the information and documents. If you do not provide me information and documents, it's very difficult for me to work for you. New certification requirements for motions. practitioners, like me being an immigration attorney, I'm a practitioner. Practitioners filing motion to reopen or motion to reconsider must now include formal certification affirming. So those are the things I'm saying. So motion to reopen, reconsider means, like, let's say you applied for something. Let's say you applied for asylum and your asylum is denied. Judge denied your application, or USCIS officer denied your application. Then we can file motion to reopen or reconsider. We can say that, Your Honor, we need to reconsider the things, or we need to reopen the things. Previously it was comparatively easy to submit those kind of applications. Now practitioners like me, I have to give certification affirming that the factual accuracy of the claims made. How do I know? So let's say you're from India. I'm not saying you're from Tamil Nadu, or you're from Kashmir. You are saying something. I have to certify the factual accuracy of the claim. I never been to Kashmir. I don't know what happened there. It is very difficult for me. So I have to get the certification from you, and then I have to certify myself, right? Also, the completeness of the submission. I have to make sure that everything is 100% complete. A lot of time previously, we would submit a form that is not 100% complete. We could say, Your Honor, my client is getting information and document. We need more time to fill it up. We need more time, blah, blah, blah. Officers, judges, they would accept that. Now they will not accept it. Number three, the good faith basis for the motion. It's good faith is kind of like a catch-all. It's, we can play with the term, but it's difficult to establish this. So these certifications are mandatory, and any failure to comply may result in procedural denial or outright dismissal of the motion. So if we cannot provide those information and document the certification, your motion to reopen, reconsider may be denied. So just the entire point of talking about all this thing is, I would like you to be very careful about your court procedure. Many times, many of my clients, they will come to me and they will act like I am responsible for everything. That's not true. Me being an attorney, I am your representative. I am going on behalf of you. It is your case. It is your case. You must provide all the information to me. If you do not provide information and document, it's really, really difficult for me to go to court and argue in front of judge on behalf of you. Earlier and more comprehensive case preparation. So let me read my slide first. By the way, if you are listening to this, this podcast from Apple or other podcast, anything in the slide, I am reading it clearly, so you're not missing anything. Don't worry. Okay, so given the shorter evidentiary deadlines and limited opportunities for continuance, attorneys must, number one, begin collecting documents and preparation the asylum narrative as soon as the client is retained. This is a big change. Previously, I saw a lot of immigration attorneys, a lot of other people, they submitted asylum application without any information or document. They just filled up the form and they just submitted. It's really difficult nowadays to do that. We need to submit the story, the evidence, and information as soon as possible. Number B, draft and finalize declarations and affidavits early in the process. We have to do it early. Ideally, even before the notice of hearing is issued. Number three, identify expert witnesses and gather country condition evidence proactively. All it says is, please provide everything proactively. Please, provide everything. Otherwise, it's difficult to, work for you. That was my last slide. Thank you very much for listening today. We are going back to Manushi.
Thank you so much, Mr. Mahajan, for such a clear and thoughtful breakdown of the current asylum landscape. You've taken a fast-charging and deeply emotional topic and explained it both clearly and compassion. Before we move to our live Q&A session, let's take a short break, so don't go anywhere. We will be back in just over a minute.
Are you afraid to return to your home country due to persecution, threats, or violence? The United States offers protection through asylum, a legal path to safety, stability, and hope. With deep expertise in asylum petitions, our Los Angeles team ensures you're never alone while seeking legal protection. Don't face danger alone. Your safe haven begins with one call.
Welcome back everyone. It's time for our live Q&A segment where we answer your most pressing questions where we will receive some important ones from what happened if your credible fear interview is denied to can someone reapply under new policy changes if they were previously denied. Mr. Mahajan, we are looking forward to your
Manashi,
insights on
before we
yes,
go to those questions, there's a question on the live session, Miss Ruma Islam. Let me read that, and then I'll go to those questions.
sure,
So,
sure, sure.
yeah, thank you. So she said, my daughter is currently an undergraduate student in United States. I would like to explore the possibility of her obtaining permanent residency, a green card in the US. We are currently residing in the UAE and would like to inquire about the pathways to obtaining permanent residency in the United States. So the good news is we have an office in UAE. We have a very beautiful office in Dubai. Manushi sits there every week. So come visit our Dubai office, talk to Manushi, and there'll be other people. Please talk to them. And if your daughter who lives in America, if she wants to talk to us, she can always, send us email, take appointment. We can discuss. She can ask question. We have a YouTube channel. In our YouTube channel, we have a lot of videos about different subjects. Please request your daughter to go through those videos because a lot of time people even do not know what they qualify for. There may be some application that she will qualify but she has no idea. So even before talking to me, I advise her to watch those videos so that she have a clear understanding about American immigration and other thing, and then if she takes appointment from me, I can explain everything to her. Also, when she will go to UAE to visit, she can also go to our Dubai office. We have office in other part of the world. So yes, short answer to your question, contact us with a specific question. We'll be able to help you, and come visit our Dubai office. We can help you. Manushi, now going back to those questions.
Sure. Okay. So let's start with the EB3 questions. So my employer submitted a labor certification application for me, but it's taking much longer than expected. What can I do?
Well, you cannot basically do anything at this moment, especially your employer just submitted labor certification LC. It's the very beginning of the process, and usually it takes, I would say, 12 to 18 months to just get the LC approval. At this moment, you really cannot do anything. You have to wait and see how fast it moves or how slow it moves. Other than that, you cannot do anything. However, sometime if you qualify for other kind of categories, so let's say you qualify for E2 or F1 or B1, B2, you can definitely come to America under those visas. Whatever you are eligible for those, you can do that while you're waiting for your EB3. But short answer to your question, you cannot do anything other than waiting at this moment for EB3.
Sure. We also have one more question from the viewer, Mr. Rajiv Saha. He is asking, may I know Dhaka office located and do come here physically?
Yes, so our Dhaka office is in Kauran Bajar, which is kind of like the center of the city Dhaka. And if you go to our website, you will get the address. But it's there's a big shopping mall called Bosundara City Shopping Mall. Our building is right next to the Bosundara City Shopping Mall. The name of the building is UTC Building. Our office is in the 11th floor, I think, Suite 3. But if you want to get the full address and phone number, go visit our website. And yes, usually I visit Dhaka twice a year. So this year I was there, I think in the month of February or March, I forget, or January. But again, I'm going to Bangladesh probably in October, first week of October. Not sure yet, but probably. So yeah, usually I visit, but you don't have to wait for me. We have people there. Go talk to them, and you can also reach out to me online. So no matter where you are from, where you live, we are globally active. So no matter where you're from, you can directly reach out to us, and our Dhaka office, you can get it in our website.
Thank you so much. Even people are asking in Dubai also when you will be available in Dubai.
Yeah, so please tell them I will be in Dubai probably last week of September. Not
Oh,
sure yet, but probably last week of September.
okay, thank you. Okay, so let's move on to the second question. I came to US on B2, which is visitor visa. Can an employer start EB3 process for me?
Yes. EB3 process can be started no matter where you are. You can be in America under B1, B2 visa or F1 visa or any other kind of visa. Also, you can be in a foreign country. Your employer can start the process, and it's a long process. It takes 3 to 4 years, sometimes even 5 years. So I actually recommend employers to start as soon as possible. But short answer to your question, yes. If you're a B1 visa holder at this moment in America, your employer can start the process. However, you must remember you cannot start working immediately. There's a long process even before you get the work permit. Without work permit, you cannot start working. You have to remember that.
Thank you. Okay. What is the difference between consular processing and adjustment of status for EB3 visa?
It's a good question. So, consular process versus adjustment of status. So, those who are already in America, within the American border, if you apply for green card, like the last step of green card, it's called adjustment of status. In short, many people say AOS, and the name of the form is I-485. You have to be within the geographic location of America. However, if you are outside of America, and if you go for the same thing like a application for green card, the final step, it will called consular process. The name of the form is DS-260, and you have to fill out the form and submit to a local embassy, US embassy in wherever you are at this moment, that moment. So you have to submit to embassy. But if you're in America, adjustment of status, you'll submit to USCIS. So those are the major difference, and also there are some minor difference. But basically, what you have to remember, if you're within physically located within the physical boundary of America, it's adjustment of status, I-485 form, and if you're outside of America, consular process with DS-260 form.
Perfect. Okay. Also, can I change employers while my I-485 is pending?
Short answer is yes. It comes with a lot of restrictions, a lot of limitations. You have to follow the same or similar kind of job. There are a lot of restrictions, but short answer to your question, yes, you can do it, but please be careful. You have to follow a lot of rules and regulations so that your application will not be void.
Okay. Okay, so our next questions will be a set from O1. So I have less idea in O1 visa. My O1 visa was denied recently. Can my employer refile it?
Yes, any application. If you apply it and your application is rejected or denied for any reason, you can definitely reapply it. Your employer can reapply it. However, what I would recommend here is I will recommend you to study what are the reasons for denial, what are the reasons for rejection, right? Because if you submit the same application again, and if they will reject it again, so what is the point? You're just wasting your time, money, and energy, right? First, study what are the reasons for denial or rejection. And if you say, I have no idea, I do not know, then there's one application I would recommend you. It's called FOIA, Freedom of Information Act. Basically, it's an application under FOIA Act. So you can ask the US government, say, hey, I applied for this thing and my application was rejected. Can you please send me all the papers and information related to this application with you, so that I can see if there's any mistake, if I did any wrong thing or mistake. So you can request the entire file, you can study. If there's any mistake or anything, you can fix it and then reapply. That will serve best interest for you. You will not waste your time, money, and energy. Otherwise, short answer to your question, yes, you can reapply.
So there is always a way that we can know what is going on.
Exactly. So that's the
Okay.
good thing about America.
Next question is.
Many people do not know. So let's say anybody, so even a random person. So let's say a random person living in Dubai, never applied for US visa or anything. He or she's file may exist within America, because America as a global superpower, they collect information from people all over the world. And then let's say you as a person living in Dubai, you think, I would like to know what American government know about me. So you can apply under FOIA and say, hey, what information and document you have about me. So then US government, if there's any sensitive information like national security or other kind of ground, they will block those information with a black ink, but they will respond you, and then they will send you a file of all the information and document they have about you.
So government, everything government.
Absolutely, yes.
Okay, let's move on to the next question. Okay, can I bring my family with me on O1 visa?
Yes, you can bring your spouse and any children under the age of 21 if their application is also accepted.
Perfect. Okay. Also, do I need a Nobel Prize to qualify for O1 visa?
No. So if you receive a Nobel Prize, definitely you even don't need O1 visa. You'll be qualified for EB1, which will give you green card. So there is some misconception about O1, and I don't blame people. I blame the people who wrote this policy, they wrote it in a way that you need like a Nobel Prize or Pulitzer Prize, like one of the top prizes to be qualified for O1. It's not that hard. If you have a master's degree or higher degree and you have some good credential, your case would be approved. So, and this is a common question I face all the time. Hey, how hard it is to get approved under O1? It's not that hard. It's comparatively easy. But,
Even I get
don't
that questions when clients come to me.
exactly.
Yeah. Okay. Can I apply for an O1 visa by myself?
Short answer is yes. And we had a presentation about this exact same topic last week. So please go watch that video. Short answer is yes. You have to register a business here in America. And the good thing is, no matter where you live, you can live in Dubai, you can live in India, you can live in Nigeria, you can live in Japan, from anywhere in the world. You can open a business here in America. You can run the business, and then your business can sponsor you. That's the short answer. But for the longer, detailed answer, please go to our YouTube channel, watch our video from last week.
Sure. Okay. So I think that's it for our Q&A sessions.
Yeah, thank you, Manashi, for this show. And I think now we have like a news, like a weekly news. Otherwise, thank you, everyone. Have a wonderful day.
Yes. Okay. And that's a wrap up for our Q&A sessions. Mr. Mahajan, thank you so much again for your deep knowledge and unwavering dedication to helping asylum seekers understand and assert their legal rights and to encourage our audience. Thank you so much for spending this time with us. And if this episode brought you clarify or comfort, don't forget to share it with someone who needs it. Knowledge is power, and in asylum cases, it can be also life changing. Immigration for All goes live every Monday at 11 a.m. EST, 9 p.m. Bangladeshi time, and 8:45 p.m. Nepal Standard Time. So please be sure to subscribe, follow, and mark your calendars. That's it for today's episode. And as always, stay tuned for few immigration news updates right after this outro. Until next time, take care, and we will see you next week on Immigration for All.
Hello and welcome to Weekly Immigration News brought to you by Raju Law. Let's take a look at the top immigration updates you need to know this week. USCIS reaches the H-1B cap for 2026. Trump targets the H-1B lottery with a new rule. A new $250 US visa fee is announced, and the US investigates Harvard over its use of the J-1 visa. We begin with the H-1B visa update. USCIS has received enough H-1B visa petitions to meet the limit for fiscal year 2026. This includes 65,000 under the regular cap and 20,000 for advanced degree holders. No new cap subject petitions will be accepted. Employers can still file extensions, transfers, or other cap exempt petitions for current H-1B workers. Now, a major policy change is being planned for the H-1B selection process. The Trump administration is working on a plan to remove the H-1B visa lottery and use a wage-based selection instead. This would give priority to higher paid workers and could exclude many international students and recent graduates. A similar rule was finalized in 2021 but never took effect. The new version may begin by March 2026. Now let's talk about an important fee change affecting most US visa applicants. A new law signed on July 4 introduces a $250 visa integrity fee for most US visa applicants, including tourists, students, and workers. The fee is in addition to existing costs and cannot be waived. Refunds may be possible for those who follow all visa rules, but the process is unclear and could take years. Employers may also face added cost. The law raises other fees for asylum, parole, and TPS applications. And finally, a top university is now under federal review over its visa practices. The US government is investigating Harvard's use of the J-1 visa program, which brings many international students, researchers, and AU pairs to the country. No fraud has been reported, but the investigation shows rising concern over how schools sponsor foreign nationals, especially those from China. Experts believe this could lead to stricter stricter rules and more oversight for J1 visa holders nationwide. That wraps up this week's immigration news. For legal help or the latest updates, stay tuned and follow Raju Law. Thanks for watching and see you next week.